declare the judgment, must welcome, we have two sets of international delegations. We have the lawyers from Cambodia, from the Royal Kingdom of Cambodia. Welcome to our court. We're very glad that you're all visiting here. And we have judges from Peru here, of the Superior Court. Thank you very much for coming here and joining us. I hope you enjoyed the sitting during the day.
Lord, we also welcome them, Lord, amongst us.
On behalf of the bar, I welcome them as well.
So let me just briefly. There are as many as 6 opinions in the case. I have authored an opinion for Justice Manoj Mishra and myself. Justice Bhushan R. Gavai and Justice Pankaj Mittal have authored separate concurring opinions. Justice Gavai and I have agreed with each other's conclusions. Justice Vikramnath and Justice Satish Chandra Sharma all have agreed with the opinions of Justice Gavai and myself. Justice Bela Trivedi has dissented. The majority of us have overruled the judgment in E.V. Chinnaiya. We have held that subclassification of the scheduled caste for the purposes of reservation is permissible. I'll just read out a brief extract. In State of Punjab versus Davinder Singh, a constitution bench held that the judgment in Chinnaiya requires to be revisited by a larger bench of 7 judges because it failed to consider significant aspects bearing on the issue of subclassification of the scheduled castes. Deciding the correctness of Chinnaiya, the following issues fall for our consideration. A. Whether subclassification of a reserved class is permissible under Articles 14, 15, and 16. B. Whether the scheduled castes constitute a homogeneous or a heterogeneous grouping. C. Whether Article 341 creates a homogeneous class through the operation of the deeming fiction. And D. Whether there are any limits on the scope of subclassification. The Constitution's 77th Amendment Act 1995 included Article 16(4)(a), enabling the state to provide reservations for the scheduled castes and scheduled tribes in promotions. The Constitution's 82nd Amendment Act 2000 added the proviso to Article 335 stipulating that lowering the standards of evaluation will not be inconsistent with the maintenance of efficiency. The amendments recognize the difficulties and struggles faced by members of the scheduled castes and the scheduled tribes during promotion. In a formal sense, the criteria of selection for promotions a priori excludes the members of the scheduled castes and scheduled tribes because the criteria which are considered to be appropriate are not accessible to them. In a more informal but substantive manner, the members of the scheduled castes and the scheduled tribes are often unable to climb up the ladder because of the stigma of incompetence held against candidates who are selected through reservation. The stereotype operates against them because they are externalized as affirmative action beneficiaries or quota candidates. The amendments recognize the discrimination through the operation of both human conduct and recruitment processes. They are an emphatic repudiation of the binary of reservation and merit. Article 14 of the Constitution permits subclassification of a class which is not similarly situated for the purpose of the law. The court, while testing the validity of subclassification, must determine if the class is homogeneous and an integrated class for fulfilling the object of the subclassification. A class which is not integrated for the purpose can be further classified upon the fulfillment of the 2-pronged intelligible differential standard. In Indra Sawhney, this court did not limit the application of subclassification only to the other backward class. This court upheld the application of the principle to beneficiary classes under Articles 15(4) and 16(4). Article 341(1) does not create a deeming fiction. The phrase deemed is used in the provision to mean that the castes or groups notified by the President shall be regarded as a scheduled caste. The inclusion of the word deemed in Articles 341(2) and 342(2) does not create a legal fiction, since it does not provide any artificial construction. To that extent, the observations of the 3-judge bench of this court in Puneet Rai versus Dinesh Chaudhary that Article 341(2) creates a deeming fiction are erroneous. Even if it is accepted that the deeming fiction is used for the creation of a constitutional identity, the fiction can neither be extended to other purposes, nor can it create legal consequences that do not logically flow from the fiction. The purpose of the deeming fiction, even if one is assumed, is identification of castes which are the scheduled castes. The inclusion of certain castes within the scheduled caste category is only to demarcate them from other castes which are not included in the category. The inclusion does not automatically lead to the formation of a uniform and internally homogeneous class which cannot be further classified. Subclassification within the scheduled castes does not violate Article 341(2), because the castes are not per se included in or excluded from the list. Subclassification would violate the provision only when either preference or exclusive benefit is provided to certain castes or groups of the scheduled castes over all the seats reserved for the class. Historical and empirical evidence indicates that the scheduled castes are not a homogeneous class. A. The depressed classes were identified based on the notion of untouchability and not in the literal sense of the term. The effect of adopting the notional and not the literal test is that the social condition of all the castes included within the depressed classes is not uniform. And B, the heterogeneity within the class is also evident from the Constitution Scheduled Castes Order 1950, where certain castes are notified as a scheduled caste in specific localities. For example, in the state of Madhya Pradesh, of the 25 castes, only 9 are scheduled castes throughout the state. The criteria used to identify the scheduled caste itself indicates that the endeavor was not to include all castes that suffered from identical forms of untouchability. The state, in exercise of the power under Articles 15.4 and 16.4, can further classify the scheduled castes. The first prong of the test for subclassification is whether the scheduled castes form a homogeneous group, integrated class, for all purposes. We have held above that even if Article 341 creates a deeming fiction, the provision does not create an integrated class that cannot be further subclassified. The provision only puts certain castes or groups or parts of them into a group called the scheduled castes. The castes or groups within the scheduled castes form an integrated class for the limited purpose of constitutional identification. They do not form an integrated class for any other purpose. We have also established through historical and empirical evidence that the scheduled castes notified by the President under Article 341 are a heterogeneous class where groups within the class suffer from varying degrees of social backwardness. That the first test is satisfied. The state, in exercise of its power under Articles 15 and 16, is free to identify the different degrees of social backwardness and provide special provisions such as reservation to achieve the specific degree of harm identified. If the scheduled castes are not similarly situated for the purpose of the law or the specific harm identified, there is nothing in Articles 15, 16, and 341 which prevents the state from applying the principle of subclassification of the class. Thus, the scheduled caste can be further classified if A, there is a rational principle for differentiation, and B, if the rational principle is a nexus with the purpose of subclassification. The scope of subclassification of the scheduled caste is summarized below. A. Since the purpose of Articles 15.4 and 16.4 is to ensure equality of opportunity of the socially backward classes, the criterion for subclassification within a class, be it the other backward classes or the scheduled castes or tribes, must be an indicator of social backwardness, and B, since the state can use any yardstick to determine inter se backwardness, it is not necessary that the criteria for subclassification and the criteria used to distinguish the class from the other classes must be the same. That is, if the criteria for recognizing the scheduled caste as a backward class is untouchability, it is not necessary that the group can be subclassified only if there is inter se backwardness due to the same identity, that is untouchability. The course of action adopted by the state is subject to judicial review when faced with a constitutional challenge. Where the action is challenged, the state will have to justify the basis of its action, the basis of the subclassification, and the model which has been followed will have to be justified on the basis of empirical data gathered by the state. In other words, while the state may embark on an exercise of subclassification, it must do so on the basis of quantifiable and demonstrable data bearing on the levels of backwardness and representation in the services of the state. It cannot, in other words, merely act on its whims or as a matter of political expediency. The decision of the state is amenable to judicial review. A, the objective of any form of affirmative action, including subclassification, is to provide substantive equality of opportunity for the backward classes. The state can subclassify inter alia based on inadequate representation of certain castes. B, the state must collect data on the inadequacy of representation in the services of the state. The inference in Nagaraj that CADA must be taken as a unit to determine inadequacy of representation, inadequacy of reservation, based on the observations in R.K. Savarwal, in our respectful opinion, is misplaced. The CADA as a unit was considered only for the purpose of preparation of rosters to draw a balance between the reserved and open seats. This court did not hold that the CADA must be used as a unit for the purpose of determining the adequacy of representation. And C, conventionally, the state has assessed if the class is adequately represented by comparing the representation of the class in the services to the total population of the state. However, adequacy of representation, when determined purely from a numerical perspective, without accounting for factors such as representation vis-a-vis posts, would dilute the purpose of the provision. The objective of Article 16.4 is to ensure effective representation of the class in the services of the state across posts and grades. Classes which are socially backward occupy the lowest of the social strata, primarily because of the traditional occupation accorded to the class by social rules. For example, certain Dalit castes are regarded as scavenger castes. Even with the provision for reservation, it is very difficult for the backward classes to shed the traditional occupation that is ascribed to them by society and optimize the opportunities even at the lowest levels. The struggles that the class faces do not disappear with the representation in the lower grades. The endeavor is to ensure true and effective representation of the socially backward classes across posts. Thus, for the above reasons, the holding in Chinaya that subclassification of the scheduled castes is impermissible is overruled. The scope and limits of subclassification of the scheduled castes shall be as prescribed in the judgment. The registry is directed to obtain administrative instructions from the Chief Justice for placing the matters before an appropriate.
Oblate to not.
Just, what's up there?
Go through the erudite and